Recording. Good morning, gentlemen. It is April 21st, 2020 at 9 a.m. We are here to deliberate in the matter of Lucky Star LLC at 11 Lynbrook Road, case 21-109A. Our hearing was February 17th, 2022. And as we have been doing, this is a virtual deliberation on WebEx. You may recall this property is a fairly small property, under an acre. It is owned BL with just a sliver of DR16. Part of the property is in the Chesapeake Bay critical area, and it is bounded by a floodplain that is the back part of, or the headwater of Frogmortar Creek. This property has a two-story building that was built as a house, and the issue before us involves a garage that was built apparently without the benefit of zoning, and it exceeds the 15-foot height normally the limitation for a garage that's accessory to a residence. There were a couple of issues involving, well, People's Council, there was a decision, People's Council filed for reconsideration, there was an amended decision on reconsideration, and People's Council filed an appeal with a motion, and before us filed a motion for partial summary declaratory judgment. The way I see it is that there were really two issues we should address to resolve this. One had to do with jurisdiction, which I don't think is a real issue. And the other had to do whether this garage on a BL site does or does not require variance relief. Based on the county's, the various comments, there were no critical area issues that would affect us, since there were the requisite findings made by depths. I'm gonna ask Mr. Evans for his views, and if he sees any other issues.
I don't see any other issues. I don't even really see much of a jurisdictional issue.
Neither do I.
Yeah. My view is that, I mean, I could go on for an hour about what my views are, but the bottom line view is that variance is required because the requirements for a residence in a BL zone are in fact the requirements of any of the closest adjacent residential zone. And the closest adjacent residential zone requires any accessory building for a residence to be 15 feet, and this is 20 feet. It was built without permit. And I think that they meet the Cromwell requirements for variance. And therefore, my own view is I would grant a variance based on Cromwell, I might be tempted to go to, I would probably add just a note that the significance of granting the Cromwell variance means that the opinion and the amended opinion from the ALJ are no longer operative. That would be my view.
Mr. Sampson?
So I have a couple of, I guess, thoughts or questions. The petitioner gave testimony that was inconsistent, in my view, regarding the use. And so I wasn't sure how that plays into this analysis, and I've wrestled with that. I know that you considered that, and I'm just wondering if you could tell me how you handled that.
Here's the way I looked at it, is that zoning really addresses use. And that the use here was totally unresolved. If it were residential, one thing applies. And I said, you know, if they built a new building that was clearly only lent itself to commercial use, then a different set of bulk standards apply. But because this petitioner was so equivocal about whether it's going to be used residentially or it's going to be used for an office or yada, 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 or retail, I took in my mind, the better approach is that because the structure has traditionally been a residence, we need to address the use as the residential use. And that would be the best way to look at this existing building and existing garage, because it is the most restrictive approach. The residential standards are more restrictive than the commercial BL standards. And there are a couple other ways we could look at it, which I'll mention. But on that basis, I would say if she ever wants to use it as a residence, that I'm not going to tell her she can't. Or if she ever wants to use it as a business, the zoning permits it. But to accommodate both, she needs the variance in this case.
So, you know,
of the residential history of the site and her own testimony.
I mean,
that use.
not to make too much of a pun here, but this project has been star-crossed from its outset, and you know, there was a screw up with the design, and then screw up with the permits, screw up with the hearings, and screw up then, it turns out, at the not just the 11th hour, but at the 12th hour, there's confusion about the use, and that just adds to the stew pot of this sort of bubbling weirdness, frankly, that's associated with this case.
Yeah.
I share, Mr. Sam, I share your concern about whether it's residential or commercial. I blew by it, frankly. Maybe that's my fault, but I just leaped without even thinking. I leaped to the most restrictive position and sort of glommed onto that. And, you know, For what?
There's another way they could have approached this that is often done at the zoning office level. It would not have changed the result in my view, but where there are two separate uses on a site, the zoning office will also impose a zoning use line, an imaginary line of division. It really wouldn't work here because then you'd need a ton of variances.
Well, and also, I mean, what was really unclear is what I don't think there was any clarity in the petitioner's mind. I mean, you know, she was almost, I don't want to say she was free associating, but she was sort of imagining things that might happen in the future or not. I mean, she really had very little definition there.
Mhm.
But the other thing is, you know, the case was presented to the ALJ and to us as a residential variance case. I think the fact that she drifted away from that at some point doesn't actually, I mean, the issues were joined, so to speak, as residential issues, I think. Is that not correct?
It was filed as a residential
Right,
variance.
right. No.
I have a copy of the petition here somewhere, and I looked at that. But bottom line, did that answer your question, Mr. Sampson?
Yes, thank you.
That meandering stream of
Yeah.
consciousness, yeah.
No, well, I
Bottom
mean,
line-
that's the issue. It was, you know, there's a lot more involved, but I just thought that was important. And there was also the statement, I don't have the context by the expert, that I found a little troubling. But ultimately, the result is the same.
So I would be inclined, as Mr. Evans is, I think the variance standards have certainly been met for this site. It's got all kinds of quirky characteristics that make it unique. I think I would grant the variance, and I would limit my response to People's Counsel allegation to say, in this case, it's absolutely required. I'm not prepared to take a blanket position that wherever I'm not willing to go as far as he goes in his ask, but it's certainly required here. I think
Yeah,
each of these are
Well,
unique.
I think his ask is, well, I interpreted his ask as just, all I really want is for the Board of Appeals to say that the ALJ's opinion is not an operative opinion. I think that I took to be the ask. And it's inherent in the process. But
And-
that's what.
and
I think he
don't
goes
have
a little further than that, but I don't think it requires a lot of debate. I think that he's asking for a declaration that the residential always applies in the BL. I might not be using the exact right language, but however he laid it out, he wants a declaration that has to be applied, because he's seeking from this court, from this board, sorry, a lot of court cases have in mind, to establish a binding precedent, because he says that county personnel have indicated that they'll follow whatever the ALJ does. So the practical effect is, as you say, Mr. Evans, by rendering inoperative those ALJ opinions, then they're not going to be able to be relied upon by the county. But again, I'm repeating myself, and I don't think it matters, because I think our decision is restricted on the facts of this case. But I think he wanted, and I think his order that he submitted to us with proposed language goes so far as to ask for that declaration. And then he would be able to use that and cite that, or I say he would be able to, he would make the argument that he's able to, and I would disagree, that he can cite in future cases back to this case to say, here's the declaration that the board found. But maybe I'm going further than he is.
Right.
No,
Well,
I agree with
I mean,
you.
my view is that if we, if all we do is say that the ALJ opinion is not operative and that this petitioner needs a variance and gets the variance, then I think what will happen, if I'm not mistaken, is life will revert to the way it was before this case started. And the way it was before this case started is that zoning in its everyday practices required a residential use in a BL zone to be controlled by the adjacent residential zoning. And that's the way zoning has operated since the beginning of, since prehistory, I think, or at least has been operating in the last number of years. And so if we were, if all we do is essentially vacate the administrative law judge order, then everything reverts back to that and life goes on with, you know, cherries and whipped cream on top.
And I would say for me, combining what you said and what Ms. Dawkins said, and I suppose it'll come down to how it's written. I just want to be careful to say that this decision is based on the facts presented in this case, because my own view is that essentially nearly every case that comes before us is going to be unique on its facts. And so I think each case needs to be considered on its facts. So I accept the statement you've just made as to the application of the zoning law. And I think it's important to impose upon it Chair Dawkins' statement that, if I understood her correctly, we're restricting this decision to the facts presented before us. And I guess case history.
Yeah, I mean, you know, neither before us nor before the ALJ. I mean, in terms of the grander issue, and then I'll shut up. But it would have been very, very useful in front of the ALJ before a grand pronouncement was made that is essentially a new paradigm. And even before us, if we're being asked to make a grand pronouncement, it would be useful to hear from the people in the county. You know, I mean, I would want to have heard about what the general practice was, how it had been, and why it was, and all this other kind of stuff. I mean, we have a very truncated, we have a truncated record here. There was a truncated record below. I mean, this was an unopposed matter. This could have slipped right through. And so I'm not I guess I'm echoing what you're saying, Mr. Sains. I'm not comfortable. I don't believe I have enough information of the kind I would want to make a huge sweeping pronouncement. All I want to do is revert back to life as it was. That's really all I'm trying to do.
I'm
And now
gonna
I'll shut up.
add, it might have been a different result in a different business zone. I don't know. I didn't look at a different business zone,
Right.
but I agree with you that we have to limit our decision in this case to the facts of this case. And I think we're all in agreement. There's no jurisdictional issue. The variance should be granted, and the application should be limited to the facts of this case of requiring the variance.
Sounds good to me.
Agree.
Okay.
We're done. We have to figure out who's going to write it, who among us gets that
Well, I'm
dubious distinction.
I'm
But
working.
we
We could decide that off the record, I think.
Yeah, we'll talk.
Okay. Okay, all right, okay,
Thank you. You have a
all.
great day.
okay.
Thank
Take
you.
care.
everyone.
Yeah,
And
bye-bye.
I'm sure I'll see you all soon. Bye-bye.
Thanks, bye.